Good afternoon and welcome to episode number 33 of At Your Service with Haber and Martinez. And you actually have Haber and Martinez today. I've entitled this episode, Okay, It's a Hearing, but Who is this Arthur guy? And the reason that we have this title is because I was supposed to be in what's called an Arthur hearing today. It got reset at the last minute. I had expected to have to cancel today's show, but last Friday our judge reset us from Monday to Tuesday. So the Arthur hearing will occur tomorrow. And I figured this was a good opportunity for Ed and I to talk to you guys about some different hearings that we routinely come across in criminal court, Arthur being the first, but there are many others. Some of them have names like Nelson hearings or Feretta hearings or Richardson hearings. And there's a lot of hearings that don't have their own particular names, but they're critical, like pretrial hearings, status hearings, conference hearings, competency hearings, stand your ground hearings. And of course, there's hearings on motions. So if you file a motion to dismiss or a motion to suppress, you would have a hearing on that, evidentiary hearings. So we can talk about all sorts of things along those lines. But why don't we start with Arthur, unless you have a better idea, Ed?
No. Start with Arthur, but I think I'd like to just add one thing. As you hear us talking about these things and why this is really, I think, going to be very interesting for you guys that are not lawyers. Most lawyers should know this, but I trust you. What I'm about to tell you, not all understand. Hearings especially, all these hearings that Michael's going to be talking about, many of them, he's going to tell you first what the hearing is for. But understand something. These hearings are weapons. What we do as lawyers, and I tell this to my clients, Mike, I'm pretty sure you do too. What we do as lawyers from day one is we look at these things like a chess game. Good lawyers, even when I was a state attorney or a defense lawyer, civil lawyer, doesn't matter. Good lawyers are 20 steps ahead. So every action we do now, we can anticipate more or less what's going to be their move, then what we would do after that, and then what would happen after that. And we're 20 steps ahead to see if we're going to get the outcome we want. These hearings many times are like pawns. They're legal, they're ethical, but sometimes we ask ourselves, is it worth it to lose our pieces on the chessboard? If I do this hearing, will I end up getting a horse or a rook, but I'm going to lose my queen? So I may not want to file the hearing, even though it would be successful, because it'll be too detrimental to me in the long run for the whole game. And so it's important to understand what the purpose of these hearings are for, but keep in mind with an eye to why some of the things we're going to tell you on why, even though we may have it, we may not want to argue it and things like that. So you understand the mindset, which is what we want to bring to you here, is what really goes on in the mind of the lawyers that are working for you. Okay? So
I want to actually, that brought up a couple of other points that kind of dovetail into that. One of them is the concept of good faith. We have obligations as lawyers to file motions that are only made in good faith. In other words, we can't just file a motion because we have a right to file it or because we could weaponize it or strategically wield it. It's also got to be in good faith. So you can't, if your motive is I'm filing this just to screw with the other side, it's probably not in good faith. And if your lawyer says they're not going to file it, you may have a problem with the client because the client, listen, let's face it, there are a lot of clients, especially criminal defense clients, who feel like they're getting the raw end of the deal because the victims are being represented for free by the state attorneys who generally accept what they say as blind truth without any corroboration or question. It's basically a rubber stamp because the defendant is obviously the bad guy or he wouldn't be there. And then the other thing, apart from the ethical obligation to file good faith motions, is when you do have a conflict with a client. So we've talked about this in other ways, but the concept remains the same. Sometimes you have a client who knows just a little too much for their own good. And they want you to pursue a course of action as their lawyer that you're not comfortable with, or you don't believe is ethical, or you don't believe is strategically intelligent. Yet they are the client and they are insisting. And that creates an ethical dilemma sometimes. Although I think when we had Mr. DeVlaming on several months ago, we did talk about that with him. Correct. And I think we were very adamant in that the client only gets to make one or two calls over a lawyer in any given criminal case, right? Correct. They get to choose whether or not they testify. So your lawyer cannot force you to either testify or to not testify. Ultimately, as the client, you get to make that choice, even if it does not comport with your
Correct.
attorney's wishes, and your attorney cannot withdraw from your case on that basis alone, right? So if Ed's my client and he says, Mike, I'm going to testify, and I say, Ed, you're going to cream yourself if you do. You're a 6-time convicted felon. That's the first thing the jury's going to hear. They're going to know that every word that comes out of your mouth is an incentive for you to stay out of prison for the 7th time. And you're going to hurt us more than you're going to help us. But Ed says, no, I don't give a shit. I want to testify. He's got to testify, and I can't walk away from that.
Correct.
The exception being if I know that he's going to lie under oath. If I know that Ed's going to put forth false or fraudulent testimony, if I know that, then I have other, obligations.
That was in another show, and we covered that, and there's ways around that. But Duff, just quickly, let's get started on the show. But I just want to point out exactly what I said. You're right with the ethical obligation. Just like a chess game, there are certain rules to the game. So, if you said to me, Ed, we could kill his queen if you take the horse from way over here on, this piece and jump 14 spaces, I'll be like, listen, that's not the rule. You can't do that move in chess. That's similar to the ethical obligation. I can't do something. No lawyer should do anything that's against the rules. However, if we can do it, just because my point I was trying to make to you is sometimes just because we can do it doesn't mean it's the right smart thing to do, because a good lawyer is not playing checkers. He's playing chess. So let's get started.
Or three-dimensional chess.
Or three-dimensional, yeah.
If you're into Star Trek.
What we do is play three-dimensional chess.
Or Star Wars. Either, both, I suppose.
Go. Let's get started.
All right, so let's talk about Arthur real quick. What's an Arthur hearing? An Arthur hearing is a specialized bond hearing for people who are being held on non-bondable charges. So here in the state of Florida, in the United States of America, as a constitutional matter here in this country, there's a presumption of entitlement to bond. But in the state of Florida, we have a much more expansive definition of that right pursuant to the Florida Constitution, and also, of course, pursuant to the rules of criminal procedure. So in Florida, if you are charged with any offense other than a capital, meaning punishable by death, or a life felony, meaning punishable by life in prison, then there is a presumption of entitlement to bond. What that bond may be, how that bond may be structured, what conditions a judge might attach to it, that's another subject for another day, but you have a right to bond. On the flip side, if you have one of these capital or life felonies, then you do not have an entitlement to bond, but you do have an entitlement to a thing called an Arthur hearing. So why do we have Arthur hearings? Well, because some guy named Arthur went all the way up to the Supreme Court of the state of Florida and argued his right to a bond pursuant to the Florida Constitution. And the Florida Supreme Court agreed. And basically, they set this standard that says you have a ability to ask the court to institute a bond, and it's a bifurcated process, meaning it's a 2-part process. Phase 1 is like a kind of like a mini trial, where the defendant says, I want my bond, even though I have a non-bondable offense. And now the state must bring forth evidence to show the court why you should not be entitled to a bond, why the evidence is so clear in this case that you are in fact guilty of a capital or a life felony, that presumptively you should not be entitled to this bond. And the standard, there are many legal standards, and this one is probably the most bizarre of all legal standards. It's the actual standard is called proof evident presumption great. This is more inexplicable than any other standard in any courtroom. It's a bizarre one, and it's a high one. It's actually the highest standard that we have. But basically, the state's got to come in with evidence that shows the judge that the proof of Mike Haber having committed this capital or life felony is evident. In other words, we are presenting to you something that shows you that he did this. And the presumption is great that I, in fact, committed this crime. So proof evident presumption great. If the state does not meet that burden, then you're entitled to a bond then and there. Again, what that bond will be is up to the judge. If the state does meet that burden, all is not lost, because there is a phase 2. And what the Arthur opinion ultimately says is that even if the proof of the crime is evident and the presumption of the crime is great, you can still, the judge, meaning you, the judge, can still issue a bond in an otherwise non-bondable offense if you determine that the circumstances are such that this individual's release does not present an undue risk to the community or an undue risk of flight from prosecution. So it goes right back to the original bond standard that you would have at your original bond hearing. But here's the difference. Everybody who's booked into a jail in the state of Florida is entitled to an initial appearance and a bond review, regardless of the nature of the charge, within 24 hours of the time of their booking. If they take you 1 second over that 24-hour mark, there's been a violation and there's going to be hell to pay. So even if it's a perfunctory hearing, even if it's just, nobody really did anything, nobody really argued anything, there was a public defender in the courtroom who never met the client, the family was never involved, nobody did any kind of investigation, all we're doing is reviewing the police report and, shooting from the hip, it's still enough to satisfy that. But if you're being held on one of these PBLs that's punishable by life or a capital offense, you're not going anywhere because they're going to hold you until you have this Arthur hearing. And the rules on timing for Arthur hearings vary greatly. There is no set in stone time for an Arthur hearing. Technically, you can ask for it immediately. The question is, when is your judge going to get around to giving it to you? Because the state's not going to file charges in most cases until at least 21 days have passed, at least in the case of a felony. And oftentimes they're going to extend that, ask for an extension. You're not even entitled to ask for an ROR until the 30th day. And so many judges adopt a policy, we won't even contemplate scheduling an Arthur hearing until after that 30 days has passed. And even then, they can extend that 30 days to the 40th day if there's good cause. So there's all these timetables and rules, but the bottom line is, ultimately, you want to get that Arthur hearing. Go ahead, Ed. I know
you want to cut you off. And here, if you've been listening to Michael, you understand now how this is a chess game because the other side has moves. They have legal rights and moves. The prosecution has legal rights and moves that they can do. Every time you move a piece, they can move their piece. And so this is where the chess game becomes, right? Because Michael just told you, you're entitled to it. But as Michael told you, you're going to get that bond review. Pretty much, either way, you're probably going to get that bond review. So the question becomes, do you want to file an Arthur hearing motion where the prosecutor might say, wait a minute, you're trying to put me in a corner and you're trying to corner me to checkmate me. And they might say, well, hold on. Let me give you a little incentive not to do the Arthur hearing because at the end of the day, the prosecutor knows sooner or later he's going to have to argue the bond amount anyway. So we start having this chess game back and forth, right? Because Michael and I, defense attorneys, love Arthur hearings because we get to depose the cop, right? Nothing has been filed, or even if it has been filed, it's early on in the case. We don't get to talk to cops. We just get written reports and forms, and nothing has really been talked about. So if we file the Arthur hearing, we get a free shot under oath that we can later impeach the cop with. So that's number 2. Here we go. Right? Number 3, we get to see their strategy, where they're coming at us from. All right. Well, the prosecutor that usually has a case like this is no moron. Going back to the analogy, they play chess too. And they sit there and think, wait a minute. Do I want to give this guy a shot at deposing my cop for free? Get him under oath? What if they think I'm going to be proving it proof evident presumption grade anyway, but I'm looking at this and I'm thinking, judge going to give him a bond anyway. Might not be worth it to them. They may want to give you a bond. They may want to argue, hey, look, let's skip the whole damn thing and go for a bond. Or how about this one? We do this too, right, Mike? How about we stipulate the proof evident presumption grade and just go straight to the bond argument? That way, you don't get to depose. They're not going to tell you this, but the prosecutor's thinking that way. I skipped the whole deposition part. You questioning my cops on the record and knowing my strategy. At the end of the day, all you want is a bond anyway. Let's move to the bond part. So there's a lot of moving parts here. That's why you need a lawyer that understands that representing you is a chess game, not a game of checkers.
So along those lines, part of the calculus that you have to do is who's your client, right? What's your client's circumstances? How ugly is it? Who's your judge? Some judges are going to be much more eminently reasonable than others. Some judges are going to be very state-oriented and not inclined to let a guy out on a PBL or a capital, especially a capital. Other judges are going to be inclined to do so. Know your prosecutor. You know, experienced prosecutors are going to do the math that Ed is putting on the table right now because they understand the game. But guess what? The reality is there's a lot of inexperienced prosecutors handling these cases right now, especially in Dade County, where they've lost about 20-25% of their office over the last year.
I think it's more. I think it's even more.
So
I think it's even higher.
They've had to promote people up through the ranks who, frankly, have no business being in the positions that they're in. At least not enough experience.
No judgment on them, right? We're not criticizing them.
No,
it's just they haven't had the experience.
It's the circumstances. If the office could if the office could magically replace the people that have left with people of the same caliber, then the people who are in those slots now wouldn't be there because they'd still be learning how to, work their way up that ladder. This is just forced promotion because they don't have the numbers. Right. But again, there are very competent, very qualified prosecutors who understand the game, and they've done this enough to know how it's played. But there are many who haven't. Right. And so, again, Ed's completely right in terms of the way that we approach it, but they approach it too. So when it comes to these Arthur hearings, and many of the hearings that we'll talk about, many of these evidentiary hearings, including, without going into a whole lot of detail, let's just say a lot of this stuff, you get away with things on both sides of the fence that you could never get away with in a trial, especially in front of a jury. For example, hearsay is admissible. There is no objection to hearsay in an Arthur hearing. So a smart prosecutor is never going to bring their civilian witnesses into a courtroom for an Arthur hearing and allow a experienced defense attorney to get at them under oath where they're not protected. They're like a deer in the headlights. So instead, they generate an affidavit, which is very bare-boned, that says, I'm the victim in this case. I know who the defendant is. The defendant did X, Y, and Z. This is how I know him. This is how I remember it. I was there. This is who else was there. And further affiant saith naught. And that's it. And then they present that affidavit. And so now what has the prosecutor done? They've eliminated the defense attorney's ability to cross-examine that witness. They've eliminated our ability to take a de facto deposition, as Ed mentioned. But they can't only go forward on hearsay. Right. So they're allowed to use hearsay, but they need more. They have to bring a witness in. They have to bring in some form of evidence, even if it's just testimonial, to satisfy this burden of proof, evident, presumption, great. Right. So what they do is they bring in the lead detective or the arresting officer. Why? Because the lead detective or the arresting officer is going to have, presumably anyhow, significantly more experience inside of a courtroom in dealing with defense attorneys than those lay civilian witnesses, the alleged victims or complaining witnesses. So they're much more comfortable in allowing their detective to take the stand. So, for example, a witness who doesn't understand the legal process, who's going to be coddled by their prosecutor on direct examination, now all of a sudden is on cross having to bear some heavy weight. The detective, on the other hand, has a report, and they don't deviate from it, and they keep it in front of them. And when they are concerned or have questions or have any issue, they look over at the prosecutor, wink, wink, nudge, nudge. I need to refresh my recollection. And they go right back to their report. They just read right off of it, basically. Right. So they're very easy to lead, and they're very difficult to pull astray. Right. So for the prosecutor, they can have a much greater comfort level in that. But for the defense, they're still ours, okay? So if you're a hungry tiger on the Serengeti, look, you'd much rather go after the limping, weak antelope. But if you're hungry enough, you're going to go after any antelope that happens to cross your path. Right. And that's what's going to happen with the lead detective who takes the witness stand during this Arthur hearing, because there's going to be a lot of questions that the lead's going to have to answer. So again, going back to this chess game, you got to look at the procedural posture of the case as well as all of these other factors. One, you're probably at a position where your client has already been formally charged, but just recently. So you probably do not have all of the discovery or any of the discovery in the case. Maybe if you're lucky, you've got a police report, maybe you have an offense incident report, maybe you are able to send your investigator out to take statements from witnesses, maybe even to talk to the victims. Who knows? But your information at that point is extremely limited. So to some extent, it's a benefit whether you win or lose, because what's your upside if you go with an Arthur hearing? Your upside is you're going to get a client who's sitting in jail without bond. But there's a secondary upside, and that is even if you lose bond, which puts you in the very same position that you were in before, you now know something about the case that you did not know before. You have more information, which makes you more effective as you go on. Right. And I just want to touch on one thing because it's very important that Ed mentioned about depositions. So a deposition is a pretrial tool in the discovery arsenal that either side is allowed to wield in either a civil or criminal case. Interestingly, I think Florida is one of only 2 or 3 states in this entire country that allow depositions in criminal court. Every state allows them in civil cases, but in criminal cases, we are in the vast minority. In fact, there was another push very recently that just got shot down in Tallahassee to eliminate criminal court depositions. So what is a depo? A depo is where a lawyer serves a witness with a subpoena, directing them to appear at a place and a time for the taking of their sworn statement relative to the case at hand. And depositions are good, they're good tools if you want to use them, but a lot of lawyers don't like to use depositions. And a lot of lawyers like to use depositions only in specific situations or with specific witnesses. Other lawyers do depos of absolutely everybody, and doesn't matter what the case is, doesn't matter who the witnesses are, they just take depos as a matter of course. Regardless of all that, depos are a two-edged sword, just like anything else. In one way, yeah, you get information, and that's good. But in another way, you also tip your hat to some degree, if not to the witness, to the state. The witness gets to look at you. They get to understand you. Now, of course, you can comport your behavior in a deposition differently than you would in a courtroom, but still, you're a known commodity by the time that witness takes the stand in a courtroom. And if their deposition testimony is flawless, then what do you achieve? So I don't know whether it's a good thing or a bad thing, and I'm not here to pass judgment on the depos, but I am going to say that when you take this Arthur hearing, they present the affidavit of the victim. You get no depo of the victim, but you do get a de facto deposition of that law enforcement officer. And all bets are off. You can go at that cop for as long as you want, as hard as you want, as much as you want. And they better have the answers, because if they don't, they're going to look like an idiot in front of the judge, and you're going to increase your chances of getting a bond.
And so here, getting back to what I was saying, and this is why I told you, look at the analogy of chess, how this plays in perfectly. So you just heard Michael say his position, right? You heard him say why defense attorneys want the deposition. And a good state attorney is going to come back, because a good state attorney, and Michael being a good lawyer, because I know he is, and we've worked for years, Michael's 20 steps ahead. So Michael, in this argument, let's say he realizes, you know what, I've got the king where I can maybe get the king in a check, not a checkmate, but a check. But Michael also knows that the opponent, in this case the prosecutor, still has his castle available. And if you know chess, you know what castling is, where if you still have your rook in his original position, you could take your king and swap it. And immediately the whole chessboard landscape changes. So here's the chess game. If the prosecutor also knows that he has his castling available, and Michael didn't anticipate that, the prosecutor might bring Michael in. Yeah, come in, suck him in, and then bang, at the 11th hour, castle him and give him affidavits. And then say, and by the way, since you were such an ass, now I'm not giving you anything. Good luck. You and I both know this judge is probably going to give him a $500,000 bond. Even if you win this, you're going to get a $500,000 bond. And Michael now realizes, the prosecutor, because he's not stupid and he has all the information, realizes your client ain't going to be able to pay a $500,000 bond anyway. So screw you. Good luck. You won the Arthur hearing, but he ain't going anywhere. When I was a prosecutor, this is what I would have offered Michael. Michael's smart. He knows that I can castle. But why go through that? Why not make it hard for Michael to put me in check? Why not say to him, hey, Mike, why don't we just agree to a bond? You want your Arthur hearing? We'll agree, proof, evidence, presumption. Great. I'll stipulate to a $200,000 bond. Now Michael's in a quandary. See, now this is the chess game. Shit. Do I go after him with the check where he could then castle me? And you know what? He might actually right. He gets a $500,000 bond. When I argue, I know this judge and I know my argument, he's probably going to get a $500,000 bond, which my client won't get out anyway. Or do I accept this offer now and get my client out and do away with all the benefits that I would get from the Arthur hearing? And now it becomes a question. What do I want away? So this is why when you go out there, guys, if you hire a lawyer and they don't understand the chess game, you are setting yourself up for failure. And then you're going to want to wonder, but wait, I won the Arthur hearing, but I'm still sitting in jail. These are just one scenario. There's many other scenarios. Plus, you've just alerted the prosecutor that, hey, man, I'm coming out swinging. And I got news for you guys. Prosecutors are not a bunch of pansies. They're not just going to sit there and take it. You come out swinging, they're going to swing right back. So you got to ask yourself, is this one that I want to start a fight just to get a bond when I could maybe get the bond without the fight? I mean, there's a lot of
some judges, and the better practice is always, I believe, some judges actually require it. They have it in their written instructions on their websites. They require a certification that you attempted to negotiate a bond before scheduling the Arthur hearing.
correct.
A lot of prosecutors refuse to negotiate. A lot of defense attorneys refuse to negotiate. Regardless, prosecutor doesn't have to agree to anything.
Nope.
And if they do agree to something, it doesn't have to be anything reasonable. But in this particular instance, in the Arthur hearing instance, again, unless you are in front of a judge who you know you have absolutely no shot at a bond, and there are some of those judges. I mean, they're never going to come out and say it, but we know who they are. There are some judges who, I don't care what the facts are. I don't care if Jesus walked into the courtroom and vouched for the client. This judge is not letting him out of jail. End of discussion.
And that's important to know because it's
You got to know it going right. You got to know it going into it.
Just like playing sports, you want to know who your referee or umpire is because you're going to adjust your game plan based on that.
Unless you're in that position, you have very little to lose in the case of an Arthur hearing. This is one of those few instances where the negative ramifications are really non-existent. So what are you going to do? You're going to upset the prosecutor because you made him work a little? Too bad.
No,
Sorry.
Again, Michael, if he doesn't give you something that's beneficial, well, then you know.
Right, if you can't,
look, screw him, and you prepare for the castling because we know he's probably going to castle. He's going to give me the affidavits, and you see the whole thing coming. If you know the whole thing's coming, then you're ready as a chess player because you've got your contingency plan for the castling.
So, as I said, the other thing is, regardless, even if you lose phase one, that is the proof evident presumption great, you still get to pitch your judge for bond. And the judge has the authority under State v. Arthur, under the Florida Supreme Court's ruling, to give you a bond, notwithstanding the fact that you have a capital or a life felony.
Correct.
All they have to do is meet the same prongs that they would have to meet in any other bond hearing, which is satisfaction that the community is safe and that the individual is going to show up in court. So why do we separate these types of cases? Why are capital cases and first-degree felonies exempted from every other charge under the sun? Well, it's pretty simple. They're the most serious cases, right? They're your murders. They're your capital sexual offenses, especially against children. They're your armed home invasions and your armed burglaries and your armed robberies and your second-degree murders. They're your carjackings and your kidnappings. They're your most serious offenses that you have, meaning the stakes are very high. They're almost all crimes of violence or potential violence. And the risk of danger of somebody who's accused of this is higher than the risk of danger of somebody who's accused of stealing a candy bar or, hit and run.
Stealing a car, which is a serious offense, but it's not, like you said,
it's of a different level. And then the other thing is, most people are not going to have the resource to flee and be fugitives and live comfortably for the rest of their lives. But when you're looking at spending the rest of your life in prison or potentially being put to death by the state, that calculus may change for a given individual, and they may take off anyhow just because the risk is so great. And so because of those factors, we separate these types of offenses. And so that's what we have going on, what I'm going to be doing tomorrow. This is an actual evidentiary hearing. That means lawyers were in the courtroom. Again, in this particular case, as with most cases, the prosecutor will not bring the civilian victims in. They will instead go forward with affidavits, which are perfectly admissible in this case, in this type of a hearing, and they will present their detective, tie up all the loose ends. That's the one person they're going to bring in and call. So in this particular case, the detective wrote a 18-page report, and I will tell you that if I were teaching the law block at the police academy and how to write up a police report, the first, second, and third thing that I would teach my officers is the law of the acronym KISS. Keep it simple, stupid. The less you say, the better. There is no good that comes out of an 18-page report. I don't care how smart you think you are. If you write 18 pages, somebody with 30 years of defense experience is going to find something in those 18 pages to beat you over the head with inside that courtroom. You're smiling, Ed. Is that the truth or is that the truth?
It's the truth. You know what? I was going to say something, but I won't.
Right.
But it's the truth. So, not because of you. I just don't want any of my law enforcement friends or even some of my to get offended.
I'm not beating on law enforcement. They know it too. They understand. You know, you really, all you're obligated to put in your report, at least your arrest affidavit, is probable cause. Just the statement of probable cause.
I used to teach at the academy several classes. I taught at the academy about writing A forms, specifically about how to write the arrest affidavits. And one of the things I covered was that, and I would cover with them all the flaws and all the mistakes and where we could pick them apart. And at the end of the class, that I would always tell them this. There are a lot of lawyers out there that are even better than I am, right? Because obviously in the middle of the class, by the end of the class, I'd be like, my God, I didn't realize all the mistakes that I make in my A forms. And I would say, okay, well, I want you to do this from now on when you write these. There's a lot of lawyers out there that are better than me, but you've heard me now tell you where I would pick apart all these A forms. So when you write these, you need to ask yourself this as you start writing. What if Ed Martinez gets this case? And you can see the chill on their face. Yep, they get it now. Be specific, keep it simple, and keep it to the elements of the crime.
Now, when you get beyond that point, and again, the more serious the case, the more reports and more data you're going to have. So if it's a basic traffic stop by a uniformed police officer that turns into an arrest for DUI or possession of controlled substances or I don't know, stolen vehicle, any of the natural things that flow from a traffic stop, you're probably just going to have an arrest affidavit and nothing else. There's not going to be any follow-up. Maybe there'll be a lab report if they find drugs. There's not going to be anything else. That's it. I mean, a DUI, there's going to be more, but on your basic criminal case, now you jump that thing up to an armed home invasion or an armed burglary or an armed robbery or an armed carjacking or an attempted murder. Then you're going to have all sorts of police officers on scene. You're going to have lots of witnesses. People are going to be interviewing people. There's going to be offense incident reports, supplemental reports. There's going to be Miranda forms. There's going to be property receipts. There's going to be crime scene. There's going to be photographs. And if you're the lead detective, you got to stitch all that together into your report.
There's one other thing. The more serious the crime, on these very, very serious crimes, there's another individual that's going to get involved in the investigative process. And you know who that is?
The state attorney.
The state attorney. We get involved in the bigger. That's why I always tell my clients, a special unit prosecutor had the opportunity to be involved in a criminal case in a way that other prosecutors are not. Other prosecutors get the cases brought to them by the cops.
But most of these cases don't have that.
Most of these
cases don't go to specialty prosecutors.
But they may.
Most of your armed burglaries and armed robberies go right to the A in any division.
Right.
And
but in some of these bigger cases, it does involve the prosecutor. And so that's thrown in the mix as well. And again, I just want the audience to understand this is a chess game. This is not that simple. It's not as simple as people believe because you're not in the system and you didn't understand it.
So we conduct this hearing. We'll go through this Arthur hearing, and we'll try to get our client to bond. So what do we do in order to prepare for this hearing? Well, the first thing we do is we send our investigator out to go do his or her homework. You've met my investigator before on this show, Carlos Fuentes. We've had him on. I've been working with him for 30 plus years. I send him out. I have him go try and interview absolutely everybody. I have him scour the area for surveillance footage. and then put in requests to try and get it. I have them take affidavits from anybody, statements from anybody, on the scene who may have some tangible, relevant information. I send him over to the police station and have him pull every available document in the police file. If the case is closed by arrest, it's all public record. Once the arrest is made, you're entitled to anything and everything that the police have in their file. State attorney's not obligated to give you a damn thing until after the case has been arraigned, you've invoked discovery, and they've got 15 days within the rules to tender their discovery, which many times they take their time and blow that time limit. Well, if you're in an Arthur hearing situation, odds are your client's sitting in jail for 20, 30, 40 days, maybe more. You don't have time to waste. You got to get to work. But that's one end. That's the proof evident presumption great end. That's phase one. That's where we're doing our diligence to gather everything that we can so that when the prosecutor does tender their information and says, all right, we'll be calling this witness, we'll be presenting this affidavit, which every judge on the planet wants in advance of the hearing, because they don't want the hearing to take longer than it needs to take, and they want everybody to be responsible and put their cards on the table. So that's phase one. But we also simultaneously work phase two, because I don't care how good you think your case is, and I don't care how good a lawyer you think you are, and I don't care how inexperienced or experienced you think a prosecutor is. You need to prepare for what if. And if you lose, you need a pitch to this judge as to why your client should get a bond, even though the proof was evident, the presumption was great. Because again, under the Supreme Court ruling, the judge has the inherent authority to do that.
Listen, when I was a state attorney, every case I ever had where somebody wanted an Arthur hearing, we all stipulated to proof evident presumption great, meaning the defense attorney admitted it's proof evident presumption great, and we still moved on to the bond part. So you're gonna get a shot at the bond. It's not like you lose. It's just, you're getting a free shot. So take it. Why not?
But if you do that stipulation, then you don't get to take any testimony and you don't get your de facto deposition.
Correct.
So if you're dealing with a obtrusive prosecutor, whether it's because they believe they have the facts and the law on their side, whether it's because they believe that they are a knight in shining armor atop a white horse wielding Excalibur, whatever it is that they may think in their mind, at the end of the day, you have to make that calculation of, hey, is it going to serve my client for me to try and secure additional information that may or may not help us during the course of this case?
Right.
Listen, all you need is that detective to say one stupid thing on the witness stand to screw up the case later.
And the smart prosecutors know that. That's why what I said earlier is, if a smart prosecutor has this case, or any Arthur hearing case, as a prosecutor, you got to ask yourself, maybe I need to make it an offer that's too good to refuse, because if I go forward with this Arthur hearing, the prosecutor has nothing to gain from it and everything to lose from it. So the prosecutor has to make the stakes higher for you to have to lose something by going forward with this Arthur hearing. If they don't, that's where Michael's right. If they don't know that they can castle, if they don't know what the problem is, that they're sitting there running for their lives because they don't have enough pieces on the chessboard, then go for the jugular and do the Arthur hearing.
Let me use a different adjective other than smart. Let me use experienced, because you can have a very smart prosecutor that just doesn't have the experience to understand the game. They don't know. They haven't played enough chess to understand how to play the game.
They haven't played enough chess to realize you were about to get stuck in a checkmate. Right.
So from my perspective, as a general rule, I think if I've got a client who's in and I can't get him out for whatever reasons, it's an Arthur hearing situation, I don't want to stipulate the proof evident presumption great unless the prosecutor was smart enough, experienced enough. and sage enough to say to him or herself, you know what, it ain't worth it. I will stipulate to a bond in this case that I know is reasonable. I mean, again, how about this one? How about house arrest? Put your client at home on an ankle monitor, 24/7 lockdown at home. Okay. Now let me just tell you folks.
We got to do the other hearings too. But this is why
I don't know that we're even going to get to another hearing.
I told you this is complicated shit.
So let me say, as a defense attorney, we have to think about a lot of stuff. We've got a client in jail. It's much more difficult to deal with a client in custody than a client who's out of custody. You got to get to the jail. You got to go through the protocols there. You got to deal with the snarls that happen at every freaking jail visit. You got to deal with the corrections officer who woke up in a shitty mood and decides to, take their time and have you rot in a room for 45 minutes before they bring your client down. Then you got to worry about the corrections officer that doesn't come and get your client out of the room for 45 minutes. And now you're stuck at shift change.
And God forbid there's a lockdown.
Yeah, I mean, the shit show at the jail is never ending.
And you know who knows that? And you know who else knows that? And you know who else knows that makes your life difficult? The prosecutor.
Right. So we have to think about that from our perspective, but it also is an effect on the client because the client's sitting in a jail cell. They got nothing to do all day. They're bored to tears. They're not at work. They're not with their family. They've got pressures. They've got financial issues. They've got stress. They've got all this other crap. And then the worst is all of the idiots in the jail that are buzzing in their ear like a bunch of bees telling them how to handle their case. And ultimately, no matter how many times you tell a client, don't talk to anyone in the jail. Everyone in the jail is a potential snitch. Everybody in the jail wants to suck you dry for information that they can turn over to the government in exchange for leniency in their case. Everybody in the jail is your best friend with a knife in their hand waiting to stick it in your back. No matter how many times you say it, if you leave them in there long enough, inevitably, most clients are going to screw up and shoot themselves in the foot.
That's right.
Finally, you got the family. The family's at home. You got kids, you got spouses, you got parents, you got clients who are working, they're supporting. You need to take all of these things into consideration as the defense attorney. The prosecutor? No, they don't have to. They should.
No,
because it's part of the administration of justice.
Right. Oh, they take it into account, but they take it into account on how to use it against you because this is a chess game.
So all of these things come into play as the defense attorney, and so you have to think about how you want to deal with those things, and it's obviously better for us to have our clients out as opposed to in. I mean, just think about it this way, and I talk about this on Fridays a lot on my social media when I do my TGIF PSAs. I always say we want you to wake up Saturday morning in the bed of your own choosing, either alone or with the company of your own choosing, and to the activities of your own choosing.
You had to throw that in there? Did you have to give us that visual?
This is what I say every single Friday. So, and it applies every day of the week. Because if you get arrested, you're going to wake up in a jail cell, on a cot or a bench. Maybe you'll be alone, maybe you won't. You're certainly not going to order in coffee. You're not going to watch the morning news or read the paper. I mean, again, it's a very different environment and lifestyle than that to which you want. So it behooves everybody to try and get you out. Now, with that said, not everybody gets out, and not everybody should get out. I mean, if we're being honest, there are some people that should be in. Right. So in this particular case, I have a client who I think should be out, and I believe I have an eminently reasonable judge, even if my prosecutor is not. So I'm going forward with this Arthur hearing, and I'm gonna throw a beating on this lead detective.
Why, right? Because in this case, the prosecutor has not made you an offer that's too good to refuse.
It's made no offer.
Too much to gain from this Arthur hearing than what you have to lose. And so this is the chess game. Yes, they can castle, but it doesn't matter because you still can get a lot out of them castling, which is the affidavit. So let's move. If you don't mind,
particular case,
the other ones and just kind of touch on what they are.
So let's talk real quick about so Nelson and Feretta. Nelson and Feretta kind of go hand in hand. They are for the client who, how shall I say, is convinced that they know what's in their best interests and they are best suited to serve their own interests.
They think they're better. They think they can be better lawyers than a lawyer.
So in a Nelson hearing, you're represented by the public defender and you are not happy with your public defender for any reason. Doesn't matter what it is. Believe me when I tell you, the reasons are limitless. You are entitled, if you cannot afford to hire a lawyer, you are entitled to court-appointed counsel. However, you are not entitled to court-appointed counsel of your own choosing. You're entitled to whoever you get, kind of like your judge. Judges are blindly assigned to cases, so are public defenders. They don't just say, okay, your name is Billy, you get Susie. It doesn't work like that. You get who you get. Now, hopefully, and here I would say especially where we are in Dade County, in one of the preeminent public defender's offices in the land, I don't believe there is a bad public defender in that office. And I think that they are very well trained and they learn very quickly and they're under the gun. They have to. So I think you're always in good shape, but still, they are weighed down by caseload. They are weighed down by protocols and systems. They come last behind private counsel. Why? I mean, because judges call private lawyers out of turn, most of them anyhow. That means the public defender who's stuck in that courtroom all day is sitting there waiting to be called on many of their cases while, 5, 10, 20 private lawyers get called first. It's just a different game. So when you want to fire your public defender, the court is required, or have your public defender change to another public defender, the court is required to conduct a Nelson hearing. And at that hearing, they want to hear from both sides. They want to hear from the defendant, the accused, hey, what's your problem? And they want to hear from the lawyer, what do you have to say about what the defendant just said? And then based upon that, the court makes a ruling, whether or not that public defender needs to be removed from the case. Sometimes you get an individual who does not want a lawyer at all. This happens a lot in what we call sovereign citizen cases, but it happens in other cases too. There are just people who have been through the system. They understand the system. They don't trust lawyers. They think that defense attorneys, especially if they're court appointed or public defenders, work for the system and do not have their interests in heart, and they're hell-bent on doing their own thing. And so in that case, there's another hearing called a Feretta hearing. United States Supreme Court is the one who came down with the Feretta ruling and basically said, hey, you have a Sixth Amendment right to counsel, but that also presumes you have a Sixth Amendment right to no counsel if you choose. You just have to make sure, you meaning the judge, needs to make sure that the individual who is asking to self-represent understands what that means. In other words, we don't want Martinez to get arrested for lurking with intent to gawk, and he decides to go to trial on his lurking with intent to gawk case on his own, and then when he gets convicted, turns around and says, well, this is bullshit, I should have had a lawyer.
I didn't know what I was doing. Well, because
that's exactly what happened. So in Feretta, the United States Supreme Court said, hey, no problem, folks. You want to self-represent. We don't think it's a good idea. We think lawyers should be, practicing their craft in courtrooms, and you clients should be listening to them. But hey, it's your life, it's your case, it's your family, it's your blood, it's your sweat, it's your tears, it's your time. And if you want to do this on your own, so long as the court is assured that you understand the pitfalls and what you're giving up and what the risks are, and that you're not going to be able to cry sour milk later if you get convicted, go for it.
Right. So they have to do that. And Michael, you are way too nice to some of the scenarios where they want to represent themselves, because most of the times it is a guy, and here's the analogy I'll make. It's the guy who played high school football and then looks at Tom Brady throwing an interception and says, I can do better than that. All
right. He shouldn't have thrown that. Shouldn't have thrown that lateral. Should have gone for the post.
He's sitting on his lazy boy on Sundays eating nachos, but he can go out there and do it better than Brady or whoever. I mean, maybe not Brady. Fucking Tannehill. When Tannehill was with Tannehill sucks. I can throw that pass. But all right, go ahead. Go out there. And when you get crushed, like Mike Tyson says, you're going to have a play until they punch you in the mouth. And then you're going to be like, I'm shit.
Everybody's a tough guy until you get punched in the face.
And so the Feretta hearings for the judge to let you know, okay, you realize you sit on your lazy boy every Sunday eating nachos, and you played junior varsity in high school. And this is a real game. This is with real consequences and real defensive linemen that want to chew your head off. You sure you want to do this? You sure you know how to do this? You ready for that? Yeah, okay. And then everybody sits back and watches the bloodbath. So, and the judges will usually appoint a lawyer to sit there and watch you and have him be there.
Which has got to be the most brutal job in the planet of being a standby counsel.
I got to be brutally honest. You know me, Mike. I'm going to be honest. They wanted to appoint me on one once, and I said yes, but I got to be honest. In my mind, I just wanted to see the bloodbath. I was just like a Roman in the gladiator days, where I just wanted to see it because I knew it was going to happen. I was just going to sit there and be like, well, I'm going to enjoy this. You bring me some popcorn.
Well, nobody likes those sideshows, but let's hit a couple of these other hearings that have names. How about Nebbia? Nebbia is another bond hearing. We talked about Nebbia once before when we had Russ Walters on. Nebbia is basically a condition of bond that says that the source of funds that's used to pay the collateral of the bond. So in state court, bond is a 10% collateral, right? I mean, a 10% premium.
Premium, the premium.
Right, not the collateral, the premium. It's a 10% premium. So if I have a $100,000 bond, I got to pay 10,000. And the Nebbia condition to a bond says that 10,000 that's put up to satisfy the premium has to be proven to be legitimate, earned, legal money. And it cannot be intangible, unaccounted for, potentially tainted dollars. And so there's only two ways that you satisfy Nebbia. One is the prosecutor agrees, which tantamount to the Arthur hearing would be similar to a prosecutor saying, okay, I want to offer you a bond X, right? So if in a Nebbia, the prosecutor says, all right, I'm cool with it, then you submit an agreed order to the judge. But if the prosecutor isn't cool with it, then you have a Nebbia hearing. And at that hearing, it's the burden of the defense to prove to the judge that the source of the premium, the monies used to pay that 10%, are in fact legitimate. You got to bring in the bank accounts, the W-2s, the tax returns, the person, where did the money come from? You have to prove it all up. Now, most times, we're able to present that to the prosecutor, and the prosecutor looks at it, signs off on it, and says, no problem. But where that doesn't happen, you have this evidentiary hearing. And again, it is an evidentiary hearing. Now, as with Arthur, stuff like hearsay is admissible. So you don't have to authenticate the bank records. You don't have to bring in the custodian of records. The individual whose bank account it is can authenticate them themselves. But again, it's that type of a hearing. How about Richardson, a Richardson hearing? Richardson hearings are for discovery violations. So where one side or the other believes that the other side has withheld or lost or misplaced or intentionally hidden.
Yeah, either way, the defense didn't get the evidence, or the state in a situation where the defense was supposed to turn it over. Either way, the other party didn't get evidence that they were supposed to get.
Right, or list witnesses or anything. You just failed to comply with the rules of discovery. And so, some lawyers do it intentionally because they think they're being cute, right? They hold off on a person, and then all of a sudden they're in trial or in a hearing, and they bring this witness in that nobody's ever heard of before. And it's patently obvious that lawyer knew this witness existed. They just never tendered them. So the issue in a Richardson hearing is whether or not this happened, and if so, whether or not there was prejudice to the other side.
Well, if I may, Mike, before we keep going. So the first question is, was it willful and intentional? Okay. That would trigger something much more serious, sanctions against the person who didn't do it. So let's say it's the prosecutor. If you can prove that the prosecutor did it intentionally, what Michael says, you knew it and you just did it on purpose, that's going to create a huge problem. But you still have, like an Arthur, you still have the safe harbor part where maybe it's true the prosecutor did not do it on purpose. They really was a mistake. Okay, well, we still have to get to the other part, which is what Michael's talking about now. Whether it was done on purpose or not, the second part is, does it prejudice the defense? Did you have a right to it? And is it important that you should have gotten it?
Is it material to the case? Because it could be something that's completely irrelevant to the case, and the prosecutor just thought it was relevant and tried to sneak it in the back door. But at the end of the day, it has absolutely no bearing on guilt or innocence.
Or the other way around. They had it, but they were like, I didn't think this was relevant.
A corollary to that would be a Brady hearing, right?
Brady.
And that's, for discovery violations where the government's in possession of exculpatory information that they withhold from you, and they don't give it to you because they want to win.
They did it right. They did it underhandedly and dirty. And sometimes the Richardson hearing can turn into a Brady, right?
And that, by the way, that happens with, by the way, for the audience, not for you, Ed, but that happens with incredible frequency. It happens much more than you would think it happens. It's extremely unethical, and it's a major problem for a Brady.
Sadly.
And so we also have Parker hearings. That's another bond-related type matter. And Parker situations are where you are out on bond for a pending case, and while you are out on bond for that case, you get arrested on another case, something completely different and subsequent. When that happens, you are still entitled, unless it's a PBL or a capital offense, non-bondable, you're entitled to bond on that new arrest. But your existing bond can be revoked by the court, period. It can simply be revoked, and you can be locked in a cage until that first case resolves.
And
That's called
Go ahead. Go ahead. I'm sorry.
That's called a Parker case. And you still, again, can apply for a Parker bond. It's not an Arthur hearing because you're not being held on a non-bondable. You had a bondable offense and your bond was revoked because you violated bond. You violated the number one condition of bond, which is don't get arrested.
And
doesn't matter if it's a good arrest, doesn't matter if it's a bad arrest, doesn't matter if the case gets.
Here's where it kind of matters, Michael. And I know where you're getting at, but you're jumping, I think, a little ahead. In that situation, based on the new case, on the new arrest, the court still has to determine that there was probable cause.
Right, but I mean, let's say 6 months down the road, that case gets dismissed.
Doesn't matter.
You can still have that bond revoked.
I want the audience to understand this. There's a reason for that. Because a state attorney, really, their ethics, and this is codified, this is in rules, the state attorney ethically should never file a case that they don't believe that they can prove beyond and to the exclusion of every reasonable doubt. What does that mean? Like I told you earlier, sometimes these cops make probable causes of arrests, and the probable cause of evidence is there. It's a good arrest. But the state attorney gets it, and a good, ethical, experienced state attorney says, yeah, but you know what? I can't prove this beyond a reasonable doubt. And they dismiss the case. Well, the judge can still hold you no bond on the original case because there was probable cause for the arrest. And that's hard sometimes for clients to understand. And to be honest with you, a lot of lawyers and judges don't understand that. They don't understand that you still have to ask the court to look at that arrest affidavit and say, do you think there's probable cause? So
there's a lot of other hearings. There's a lot of other hearings that we could have talked about here, but we're out of time at this juncture. Maybe we'll do another show and hit the balance of them. Mike, you
want me to tell you why you thought? I'm going to tell you something for everybody to understand this. And if you do this in your own life, you'll understand what I'm saying. Michael thought we were going to get through all of these. I told him we might be able to get through one or two. And this is why. You know why, Mike? You and I have been doing this so long that our mind, when it comes to these things, is like a computer. We analyze all the data in 10 seconds because we've done it so many times.
Yeah, but you kind of look like Hal. You remind me a little bit of Hal.
To sit here and explain to people what goes on in our head, this is why sometimes clients say, why do you charge so much? Brother, because we're so good at it that when it takes somebody else who's never been doing this 10 hours to figure out, Michael and I do it in 5. Because our brain is already doing, we've been doing this. And you calculate all these things like this, Mike, you don't even think about it.
Well, but you were right. We definitely spent 50 minutes on Arthur hearings, and we could have done more if you didn't stop, if you didn't push us to other stuff. Anyhow, I hope that it was interesting and informative for the audience. I hope you got something out of it.
Hopefully their heads didn't explode from
it's information dump. But really, that's the crux of it. At the end of the day, we just wrapped up talking about Nelson and Feretta hearings. And at the end of the day, this is why you don't want to be in a Nelson or a Feretta hearing. You want to hire a lawyer that you can put your feet up, go to work, go home, live your life during the pendency of your case with the comfort that your lawyer is handling everything because he or she knows what he or she is doing. And look, we don't have crystal balls or ESP. We can't ethically or in reality tell you what's going to happen. But we can certainly lay out our strategy and explain it to you. And the truth is, if you want to know what's in your lawyer's head and your lawyer doesn't have the peace of mind to give it to you up front, ask. Just ask. Right. It's that simple.
That's it.
All right?
Good show, Mike. I hope you guys
enjoyed it. Thank you, Ed. Appreciate it. And by the way,
I saw it. And I wore my NRA hat.
All right. Well, we're right on top of it. We're supporting our brothers and sisters over on the other side of the pond.
Absolutely.
Who really need our thoughts and prayers. Folks, thank you very much for tuning in. We appreciate it. We always love to share what we can with you. We hope you got plenty out of it. And we'll look forward to seeing you next week on episode number 34, where Ed and I can be back at your service. Take care and thanks again.